Well, friends, now that a D.C. appeals court has ruled unanimously that Donald Trump is not above the law, Donald Trump is not a king, Donald Trump can be prosecuted for the crimes he committed while in office, we still have one justice hurdle ahead of us: the Supreme Court. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, we are this close to having Donald Trump's federal prosecution in Washington, D.C. back on the trial track. That's his case for trying to unlawfully and unconstitutionally overturn the results of the 2020 presidential election. The trial has been on hold while Donald Trump made this asinine claim, this unsupportable claim that he's above the law, beyond the reach of the courts or the criminal statutes, that he has absolute immunity against prosecution, meaning he can commit all the crimes he wants against the people of the United States, and he can't be held accountable. He can't be prosecuted for it. Well, you know that the appeals court in D.C. unanimously just shut that down. And we're this close to getting the trial back on track. Now it's up to the Supreme Court. Let's talk about why the Supreme Court has absolutely no reason, no legitimate reason, to grab hold of that case, accept it for review, and then make us all play the waiting game for weeks, perhaps months, before Donald Trump's case gets put back on the trial track. Before we turn to why the Supreme Court has no legitimate reason to review the case, let's start with the new reporting. This from the New York Times. Headline: Federal Appeals Court rejects Trump's claim of absolute immunity. And that article begins: a federal appeals court on Tuesday rejected former President Donald Trump's claim that he was immune from prosecution on charges of plotting to subvert the results of the 2020 election, ruling that he must go to trial on a criminal indictment accusing him of seeking to overturn his loss to President Biden. The unanimous ruling by a three-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit handed Mr. Trump a significant defeat. And friends, now I'm going to skip ahead in the article because here's what I want to focus on. In another significant part of their decision, the three appellate judges also circumscribed Mr. Trump's ability to use further appeals to waste more time and delay the election case from going to trial, a strategy the former president has pursued since the indictment against him was filed in August in federal district court in Washington. The panel said that Mr. Trump had until Monday to ask the Supreme Court to get involved in the case and continue a stay, that is a pause, of all the underlying proceedings. The case was initially put on hold by the trial judge in December. That was because Trump had appealed this absolute immunity issue, and so that meant everything in the trial court had to come to a screeching halt, had to stop. The article continues, but the panel imposed a rule designed to discourage Mr. Trump from making an intermediate challenge to the full Court of Appeals. It said that if Mr. Trump instead took that route, trial preparations could begin again after February 12. If the question does reach the Supreme Court, the justices will first have to decide whether to accept the case or to reject it and allow the appeals court ruling against Mr. Trump to stand. If they decline to hear the issue, the case would be sent directly back to the trial judge, Tanya Chutkan. She scrapped her initial March 4 date for the trial last week, but has otherwise shown every sign of wanting to move the charges toward trial as quickly as possible. If, however, the Supreme Court does accept the case, the crucial question will become how quickly the justices act in asking for briefs and in scheduling arguments. Should they move rapidly to hear the case and issue a decision, there remains the chance that a trial on the election charges will occur before the general election in November. But if the justices take their time, it's possible a trial could be delayed until after the election. If that were to happen, and Mr. Trump were to win, he would be in a position to ask his Justice Department, his weaponized Justice Department, to dismiss the case or even seek to pardon himself. So yes, that last little bit there sets out the parade of horribles that not only could, but very likely would occur if Donald Trump is not taken to trial before the 2024 presidential election. And if the Supreme Court decides to grab hold of this absolute immunity issue and take it on appeal, take it for review, boy, the prospects of getting Trump to trial in his D.C. federal prosecution before the 2024 election, the prospects grow a little dim. But here's why the Supreme Court has absolutely no legitimate reason to accept the case for review and slow down the Donald Trump train in the direction of a trial. The appellate court essentially used the very words of the Constitution, the language of the Constitution, to reject Donald Trump's absurd notion that a president can't be prosecuted for crimes he commits while in office. Let me give you two examples. The appellate court opinion sets out that the president has a constitutional duty, a duty to take care that the laws be faithfully executed. That's a presidential responsibility that is expressly set out in the Constitution. In what world, in what rational understanding of the English language does the constitutional duty to faithfully execute the laws of the country somehow, in those words, bestow upon a president the right, the authority to violate the laws of the country? That makes no damn sense. Indeed, the notion that he has an absolute right with impunity and immunity to violate the laws of the country that he is obliged to faithfully execute, it just runs contrary to the express words, the language of the Constitution. Let me give you another example. The impeachment judgment clause, and this is mind-blowing, right? Anybody with sort of a third grade understanding of grammar and of the English language would reach but one conclusion. The impeachment judgment clause says, and I'm just going to break it down in layman's terms, even if a president is impeached, even if the House of Representatives impeaches the president, then takes that article of impeachment, gives it to the Senate, and the Senate conducts a trial on the article of impeachment and convicts a president and removes him from office, even if a president is impeached, that president shall still be liable for indictment, trial, judgment, and punishment, even if he is impeached. In other words, even if a president is impeached, he can still be prosecuted. By the very language of the impeachment judgment clause, presidents can be prosecuted. Not only can they be prosecuted, they can be prosecuted even after they are successfully impeached and removed from office for the very same conduct. that language in the Constitution, those words, the impeachment judgment clause, is actually a constitutional declaration of a president's susceptibility to prosecution. You could explain that to a third grader and they would get it. Apparently, Trump's lawyers must think or hope that the judges and justices who have to rule on his absolute immunity claim never made it out of the second grade, because the express language of the Constitution screams a president can be prosecuted. So that's why I say, friends, the Supreme Court has absolutely no legitimate reason to grab hold of this issue, to grab hold of this case, and then to do nothing but waste the time of we the people as we wait for our day in court, as we wait for justice to come for the crimes Donald Trump committed on and around January 6th against we the people, robbing us of our vote, right? Disregarding the expressed will of the American voters and deciding he would unlawfully and unconstitutionally retain the power of the presidency. Because the Supreme Court does not have to accept a case for review simply to say to the lower appellate court, we agree. We agree. They don't have to take a case for review if they agree with the result that came out of the Court of Appeals, which they have to if they bother reading and applying the plain language of the Constitution. So the only reason, in my opinion, that the Supreme Court would accept review of this case and just stop Donald Trump's trial dead in its tracks for goodness knows how long, is to do a favor for Donald Trump, though, right? Slow everything down so he could perhaps retake the reins of presidential power in the horrific event he ends up being the Republican nominee. There's no legitimate reason. There's no constitutional reason. There's no rational reason. There's no non-nefarious reason the Supreme Court would want to stop Donald Trump's trials dead in its tracks. He doesn't have presidential immunity. The courts ruled that he doesn't have presidential immunity. The Constitution makes clear that a president is not immune from prosecution for his crimes. So the Supreme Court should leave its damn hands off of this case, because I'll say it one more time, there's no legitimate reason for them to take it up and put a stop to the trial of Donald Trump. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.